So I guess I'll get started. My name is Frederick Spaeth. I'm an attorney with Dilworth IP, and here today for smart branding moves from inception to protection. Um, I want to just start off by thanking Steve Rodriguez for arranging this and inviting me to join, and also Nathan Yusko, the track captain, and also Stephanie Lee, who I just met this a few minutes ago, but she's helping me organize this interaction. So thank you all. A little bit about me. I'm an attorney, JD MBA. I've been working in the field of intellectual property, patents, trademark, copyright for quite some time. One of my favorite areas to work in is with startups, because it's when I'm working with folks like you at a time like this that the impact of the advice we give just multiplied so many times. And you can see it as your businesses grow and progress down the road. A business that starts today and practices good IP policies, 5 or 10 years from now, they're in an awesome position. I'm going to share my screen. I have some PowerPoint screens, slides that'll just sort of help us walk through, help me walk through and organize what we're looking at. So we'll start with this. Here we are today. So next, oops, I hope that this, oh, here we go. Okay, so here's my agenda for today. Talk about defining your brand and the difference between a brand and a trademark. A lot of folks, think that they're the same thing. And if you read the articles and literature about it, there's a lot of talk that sort of use those terms interchangeably, and they're really not. And you become attuned to that, at least I do from my MBA background and talking with brand managers and such. Then I'm going to talk about the process of how to choose a mark with issues of strength and alignment and clearance. And then once you know what you want to use, how do you get rights to it? And then once you're using it and you have rights, what does it mean to protect it? And what do you do about that? Okay. So defining a brand. And forgive me if you've already been through this exercise. If you haven't, it's very important, worth doing among yourselves, among your team. And it can be very helpful to get a consultant in who has experience in helping teams define their brand. But basically, for our purposes, for my purposes, what the brand is it communicates who you are to your customer, all right? It connects your products and services to your company values. You'll see literature and advice about forming mission statements and vision statements and such. These are like the touchstones that can guide your strategies and techniques on how do you do things for your customers and internally. It guides strategic advertising and marketing. And then the mark itself, when you use it in the way we'll talk about, it can carry those messages to your customers and to potential customers. But essentially, the brand is about who are you for your customer? What do you want them? What do they think of you? And what do you want them to think of you? Okay. Now, the trademark or a service mark is more familiar as what people call their brand, and they're very closely linked. But how do you choose one? So I picked out here 3 categories of concerns and issues to think about. You want a mark that's going to be strong rather than one that's weak. We'll talk about what that means. You want it to align with your brand message, okay? And finally, once you've gone through the process of selecting these things and evaluating them, you want to have some candidates. because you should go through a process of making sure that the one that you want is available. Okay, and that's what I'm calling as clearance. So, what is a strong mark? Well, one of the big issues that you should know about is that you want your offerings, your company, your reputation, your brand to stand out. It's got to be different so that when people become familiar with it and come to know you and talk about you, word of mouth and such, all that stuff gets directed to you. And excuse me a moment, I got to just scratch my throat. And so to stand out, it, there are various ways in which you can end up choosing a weak mark. But there are certain parts of a word mark, for example, that are very attractive to certain marketing goals, but they really don't help as far as creating a unique identity. And just for kicks, I did a quick search in the U.S. Trademark records and found many thousands of marks that refer to their services or goods as the super or smart, smartphones, smart tools, whatever. Um, Other ones that want to impress customers or potential customers that their offerings are really good or maybe the top of the line. There are so many of them that say that ours is gold in one way or another. Um, okay, live applications and registration include RX, and there are more than 250 of those just for software. So this points out that there are lots of elements and ways that you can identify your services or marks to the public in ways that might feel helpful, but actually don't help you stand out. So a strong mark requires distinctiveness. Um, Aside from standing out, it also requires distinctiveness from what it is you're offering. Okay, what does that mean? Well, there are different ways to look at it, different examples, and here are a few of the ones that should be familiar. A strong mark could be something fanciful, so it's a completely made up word or maybe just an abstract symbol. We've got three of those at the top. Um, the challenge in choosing these is that until you put your marketing efforts out there, people don't know what the heck it is. Um, Think about the first time someone says, "Oh, you should Google that." And what the heck are you talking about? Okay, it takes time to educate people to what that means, and yet these are the strongest marks that are out there. And if that seems a little bit confusing, um, I'll talk a little bit later on about how such abstract or nonsensical words can actually be the strongest. But if you go down to the next level, arbitrary. So these are words that are actually our words, and they were applied and used with the services and goods, but they really don't tell you anything about them. Amazon, it's a place in South America. Shells, how does that relate to gas stations, and blue diamonds as far as nuts? So these are what are called arbitrary choices, and there's no inherent connection to the product. Um, at the same time, these are also very strong marks for very much the same reason. Um, in the fanciful and arbitrary, these are really in the strongest level. I'm just checking to see, have I got a comment coming in, a question? Not yet. Okay. I'll take a break soon and invite any questions. Uh, but I think of it this way. This is the way I explain it to my clients: is that these fanciful and arbitrary marks, because they don't talk about the goods or services directly, um, there's sort of a void in there as far as the meaning goes. And your company, when you choose such a mark, can fill that void with your brand message. Okay, and we'll talk about how that brand message gets connected to these arbitrary or fanciful marks in a little bit, but it's going to be it's through your advertising, and it's through your customers' experience and word of mouth. There is a level, what's called suggestive, which are still pretty strong, but they do kind of lead you or lead their customers to what it is you're offering. Uh, Not directly. You got to think about it a little bit, like the word Airbus, as far as relating to airplanes, or Netflix, a business of delivering movies over the internet. Um, an Energizer, that's fairly vague as what it might be. It's not a drink, but it does energize and power electrical devices. Um, these are fairly strong marks too. Not quite as strong as fanciful and arbitrary, but they're still pretty well respected. Um, Now, so even though these really strong marks, the arbitrary and marks that don't really directly say anything, you still want them to be pretty much aligned with your values or with some connotation that you want your customers to have. So people have looked at Amazon, just by way of example, and point out that, first of all, what people already know about the word Amazon is it refers to something really big. It has connotations. Okay, the area on the globe is huge and is sort of mysterious, but also powerful. Um, and these are things when Bezos started Amazon, wanted people to think of him, or he certainly aspired to, and it served him well. The symbol part of it is that little arrow, which is very interesting. Part of it looks like an arrow, which means you're getting somewhere, getting what you want. Things are coming, but also it looks kind of like a smile. When you go to Amazon and use their services, you're going to be happy. Okay, so this is a really smart choice of mark. Blue diamonds, again, not quite as maybe strong as far as connected to the brand, but still, diamonds are highly prized. Maybe blue diamond. I'm not a diamond expert, so forgive me about this, but maybe blue diamonds are even more impressive. And by putting it together with the almonds, the company is saying, hey, we have a really good product here. You're gonna like these almonds. Now, I pointed out that the suggestive marks come a little closer to what these companies were offering. You know, Airbus is not just descriptive; it doesn't directly connect because there's no such thing as an Airbus. It's a little bit incongruous actually. Uh, but yet, if you think about it, it kind of does connect, and it does help um, people remember. So you might have gotten an explanation at some point of what Google, what does it mean to Google something, but you might forget because it might be hard to remember. You might not come across it all that often. Uh, but the first time you heard someone talk about an Airbus, and you say, "What's that?" The next time you hear the word itself, it kind of leads you to where you need to get to understand it. So that's why these are suggestive. um, in the quest of putting this together, I went around to find some more contemporary examples. And I came across this one in one of the a reference to this in one of the blogs, and I wanted to share it with you to see how all this gets put together. So uh, under the text in the middle of the screen here, they talk about what they do and their approach to it and what they want you to know about them. They do credit card processing. So if you're a vendor of some sort, they will help you get paid. And they're going to make it simple and get you paid quickly. That's what they want you to know. But take a look at what they're using here as their mark. They've got a hybrid here of word and a symbol. And I hope that you can see this little tagline underneath. So they've got a good combination of marketing collateral here. The word itself, card runner, again, not really simply descriptive, but it does suggest, if you think about it, what they're going to be doing for their customers. Okay, they're doing it quickly. Running is going to be fast. Um, they've got this image of some kind of, let's guess, I'll take it, I guess it's a cat, which are known to be very fast runners. And finally, they've got this tagline here: "Your partner in processing." Again, you're not just a customer; you're a partner. You're really important to us. I really like I really like this presentation. And by the way, I'll talk a little bit about registering marks. How you've seen whether companies use the TM or the SM versus that circle R, when you can do that and why you should. You don't see it here. And I looked into that. I was kind of curious because these people are pretty smart about what they're doing. But it turns out that at one point, Card Runner was actually registered for a completely different thing by somebody else. They could not go and get registered, or maybe they didn't try. But I have looked, and if you're out there, Michael Molman, you should know that the registrations that were online have expired. So go for it. Okay, so yeah, it's just a. I didn't realize I could do that. How about that? Okay. So I'm talking about getting a strong mark, but what does a weak mark look like? What is it you're trying to avoid? And why do marketing people like them? Well, the weak mark actually describes what it is you're selling. So, the customers, potential customers, people looking at your advertising copy don't have to work too hard. If they just see the name and, hopefully remember it, they'll get an idea of what it is. They don't have to read through, a long ad copy. They don't have to spend a whole lot of time looking at the video ad. So these are examples of weak marks. Modern camper, for sales of camping equipment. And it might be a store, it might be a magazine, you know. Carbon eliminator for a fuel additive that removes carbon deposits. Okay. Once you have a little bit of a context, you know immediately what that is. The problem with these, with a weak mark, is that it talks more about the product or service on a generic level. I mean, there may be other magazines or stores that sell camping equipment, and there might be other products that remove carbon deposits. And, wouldn't they be described, or couldn't they be described in these ways? And if so, do these marks talk about the company that's offering these? Or do they talk in general about the products in that category and maybe, invoke images of competitors? The fact that they don't have a strong association with the company that's offering these particular goods and services makes them weak. And the difference between a strong mark and a weak mark is what you can do with your mark uh, in the future when you think someone else is infringing. Okay? And we'll talk about that in just a little bit. Just checking my notes to see if this is time to. Oh, there's one more screen I'll show, and then I'll maybe take a pause and ask if there are any questions. The ultimate fail in a mark is something that directly tells customers what it is, and they don't have to think about it or anything. And it definitely, other competitors are going to probably be using those same words. So, people have I've seen applications for screen wipe for cloths for cleaning screens. A company called Analog Devices for an outfit that sold analog devices. Ice pack, for something that's basically a block of ice. You can never protect this sort of thing. And obviously, it really doesn't do anything as far as pointing, customers to a particular company, yours, rather than someone else's. So these are what I call a branding disaster. You can get here by accident, and again, I'll talk about how and why. But there are certain words that have become generic for things that used to be trademarks, and they lost their esteemed trademark status because the people that owned them, the companies that owned them, didn't follow best practices. Examples, uh, aspirin. Everyone recognizes aspirin as that's just that generic thing you get in the store, and it might be bufferin or Excedrin or something, but aspirin used to be a particular trademark, but it became generic. And there are others that are out there that are in danger of going that way. Uh, I used to see ads all the time for Xerox. People don't use copy machines so much anymore, but we used to. I'm old enough to remember when we did. And Xerox was the leading manufacturer of those machines. And people used to have this expression, oh, just, make me a Xerox or go Xerox this. And the Xerox company fought very hard to stop people from saying that because it sounded generic. Pretty soon you people would be saying, oh, let's get a Xerox machine from Canon. They offer a better deal or something, and that would have been a disaster. So they worked hard to stop that. They took out full page ads in a variety of magazines to educate people that not to say, Xerox is for me, but rather, make a copy of this on on the Xerox machine. Okay. So before I move on to protectability and what the benefit of strength, I just want to invite anyone to send in any questions.
Yep, and we do have some questions in the chat.
So I need to check the chat. Let's see here. Stop share. Oh, okay. Great. Is there a difference between a trademark and a service mark? Not an important difference. The only difference is that the word trademark can be an umbrella term for both, and I use them that way. A service mark is simply a mark for services. A trademark could be a service mark. Traditionally, it's also encompasses marks for products so that you can see them. The Nike swoosh on a pair of shoes. That's not a service mark because it's on a product. That's the only difference. What happens when your trademark becomes a common catchphrase like Google that? Does that affect your trademark protection or enforceability? Yeah, I just mentioned a failure of that kind. It's called genericide in the legal community anyway. The mark got killed through use that made it generic. Even so, people now say Google that, and the mark Google is incredibly strong. Okay, so is there a disconnect between what I said and that fact? Not really. The issue is when you're starting out with a new mark, using it properly, and we'll talk about what that means, is really important in order to prevent genericide. Google can get away with it and let people get away with it because they're so big and already so well known. Okay, and there's lots of other examples of that too. A $64 million question: how do you come up with a mark concept without going to a consultant? That's a great question, especially an arbitrary mark. Well, I hope I've given some hints about that. It takes, if you do it internally, okay, it takes some really good brainstorming. And to guide you on that, you go back to your mission statement and your vision statement. Who are we? What do we want to be? And then try and find words that are, in that ball field, but that don't actually directly describe what it is you're offering. And again, the more abstract you can get, the better, because if there's a void in between your actual mark and what you do, you get to fill that void with your branding message. Telehealth bathrooms, an inventor of five smart Internet of Things assistive bathroom fixtures. Crowdfunding. The smart toilet is non-provisional. Non-provisional. that sounds like a patent, um, which is a talk for a topic for a different presentation. Happy to do it though, Steve. So let me know if you'd like that. Um, s- Non-provisional. So yeah, so just real quick, as an aside, non-provisional is probably the quickest, easiest, cheapest way to get a patent application on file. It might, if you've used the name, uh, your trademark name, whatever, smart toilet, uh, in the patent application, um, that really won't help as far as the branding goes out in the public, in the marketplace. Um, you want to go to the U.S. Trademark Office and register there. And I'll be talking a little bit about that too. Okay. Um, I think it's a good time to get back to sharing and get to our next screen. Here we go, screen. Uh, so why go with a strong mark? Strength goes to protectability. Okay, there are competitors out there, and they will have their own brands and their own marks. And you want your branding message attached to your mark to develop a reputation, word of mouth, customer loyalty. And when someone else out there, one of those other competitors, a newcomer, comes along and chooses a mark that seems to draw off of what you're doing and what your message is, that's a problem. So, and there's actions you can take. Um, One source of examples of this is that in the U.S. Trademark Office, they actually deal with conflicts at a certain level. And so I picked out this example here. Red Bull was a really strong mark for energy drinks. Okay, a competitor came out with something else in a similar vein, and they went opposite. Let's go pink cow. Okay, now on the face of it, no one's going to get confused between a pink cow and a Red Bull, but Red Bull is a strong mark. Okay, by itself, it doesn't really tell you anything about what the product is. And so when they had the impression that Pink Cow was really drawing off of what they were doing and trying to get their mark registered, Red Bull was able to successfully stop it. And the reason being is that even though, side by side, they look very different, the fact that Red Bull was strong and that Pink Cow was just in the neighborhood gave them the strength to get recognized by the authorities who said, no, Pink Cow, you're not supposed to be doing that. Okay. A strong mark gives you that ability right off the bat. Okay. A weak mark, the ones we talked about that are suggestive, I'm sorry, descriptive, the ones that were descriptive, like modern camper. Um, when you, out of the gate, you start a business with a mark like that, you can't do this. You can't protect it that way. If it's generic, you'll never protect it. Okay. If it's not quite generic, but it's descriptive, carbon eliminator, maybe no one else is actually using that particular phrasing, um, or modern camper or something. Um, there's something called acquired distinctiveness. If you're the only one using that and you're successful and you gain a reputation over time, used to be a 5-year uh, benchmark on this stuff, but even that benchmark is gone. You need to be able to demonstrate lots of sales, lots of advertising, recognition among customers that this mark is not just descriptive of your goods or services, but it actually has brand loyalty built into it. That's called acquired distinctiveness, and it can be really hard to show, especially for a young company. Um, I included suggestive marks as strong marks, but they're not quite as strong as the ones that were arbitrary or fanciful. So here's an example. When a company called Ucore objected to Supercore coming out with a competitive offering, They tried to block that, and they were not successful. And the reason was that, as I recall, this was about computer technology or something. They said, the word core is kind of a very common thing, and it kind of points to what you're doing. It makes your mark weak. Therefore, we're not going to give you as much elbow room around the impression that your mark makes, as we did with Red Bull. Okay, so this provides. I'm hoping that this slide provides a really good example of the advantage of a really strong mark, which doesn't directly talk to the product or service by itself, versus one that sort of suggests where the customer ends up with when they go with that product. Okay. All right. So you asked about how do you choose a mark, and I talked about going back to your mission statement and your vision statement, what you want customers to think of you, and what you're promising them they will think of your company. But once you have arrived at that, there's still another step to go. You want to clear the mark, whatever it is you've chosen and landed on. It's a really good idea to have a small set of candidates because you want to clear it. I talked just now about protection and about having some elbow room around your mark and stopping others from taking on your branding message. But people who are out there already with marks, they have the same right to do that. And you want to make sure that when you get out there, you're not stepping on those toes. So you want to avoid conflict with the mark of a senior user. Senior means that they got there first. Okay. If you successfully avoid that kind of a conflict, you'll do a couple of things. First of all, because you're making sure you're different from what your competitors look like, you're enhancing how distinctive you are. You're going to stand out more because you're distancing yourself from the others. So that helps to increase the strength of your mark. You'll choose the stronger ones among those candidates that you had. And protectability, again, because it's farther away, you'll have more elbow room around it that'll be recognized in the trademark office and in courts if you have to get there. And finally, it'll make it easier to get through the registration process. Okay. How do you clear a mark? It can be expensive. Really, the industry standard way to do it is to go with a commercial search firm. And here are some names of some. We do this for our clients when they allow us. We always recommend it, but it does cost some money, and it's often a challenge for startups that have very tight budgets in all kinds of areas of their business. So I'm putting up here a little bit of do it yourself. You can go to Google and just do some searching on your candidate names. Go to the marketplaces where you're going to sell and see what's there. If you're selling on Amazon, search on Amazon for these things, and whatever other social media that you might be using, Instagram and so on. Go to the official registers. The USPTO database is limited. It only shows you what's in their records, but it's open, and it's a really important one. It's basically the first place to go, at least as far as your lawyer would be concerned. And the USPTO has an open database. There's a database for the European community. And in fact, the World Intellectual Property Organization has a global brand database that reaches all the participating countries that contribute to it, and it's virtually all of the industrialized countries that you'd want to go to. And again, this search firms. Failing all of that, or maybe deciding that you're not going to do it, and it might be because you did your brainstorming, came up with something that's so ideal that you love it, and you know your field, you know the competition. There's nothing out there like it, and so on. You're just going to skip past all of these sort of things. You can just you know decide just to go forward and use it, um, and maybe apply and hopefully apply for registration. And I've indicated that this is sort of trusting your luck because hopefully your knowledge is full and complete, but you never know. Um, and by the way, I'll point out in another screen or two that even if you go through these prior clearance steps that I mentioned, you still never really know, but you know a whole lot better than you did if you don't do them. I'm just going to check to see. I got a new questions coming in. To begin protecting yourself when you're just starting out, any specific action or language to include, or state or website documents demonstrating intent of some kind that can help later on for filing. Absolutely. Um, the one option you have in the United States, once you've adopted a mark, let's say whether or not you cleared it, but you've got one, you want to use it, you're planning to use it. Um, at that point, if you haven't done anything else, you have no rights in it yet. Okay. There's two ways to get rights in there. One is to actually starting a business and let your customers see it. And I'll talk a little bit about how that goes. But the other way, and the only way to do it in this country, is to file a trademark application based on a bona fide intent to use. Okay. And again, you can do this through the USPTO website. Um, and and there are a variety of services out there, law firms like ours, but there are others, and the costs vary quite a bit. The USPTO for a simple, basic application, you're looking at if you go online and do it online, and these days I think they were transitioning to online, um, and I think these days maybe it's the only way now, and the fee is $275 for a basic application. Some of the other services that help you, basically they work on the front end of the interface. The USPTO interface is a little clunky, and there are blanks to fill in and such that aren't always obvious as far as what they mean. So there are services out there that essentially create a friendlier interface. They also, if you pay a little extra or here and there, they'll offer you a little more help. And the final alternative is like going to a firm like ours that will help you make a lot of decisions about what those blanks should be filled in with, and how to deal with the responses that come back from the trademark office. Okay, so I just want to make sure that I'm still sharing my screen. Let's go back. Not yet. All right, so let's do this again. Another talking point here. Okay. Next stop. So I talked about knowing and not really knowing. All of these steps about avoiding conflicts is about risk mitigation. Okay, not elimination. You can pay for a high-priced search, and you'll learn a lot about what's out there, and it's still possible that something might get missed. And the reason is, think back to, for example, Red Bull versus Pink Cow. Okay, a lot of these search mechanisms, you go to the USPTO or the WIPO or the European search engines, and you put in text. And if you've got a word mark that you're thinking about, you put in how many exact hits are going to come back. And if you put in Red Bull for your starting up of a power drink company, would you ever find something that looked like Pink Cow if they were ahead of you? No. And it doesn't have to be all that different either to be relevant. There are different ways of spelling words. people use letters. For example, easy might be EASY. It might be the letters EZ, and so on. There are lots and lots of variations. The commercial search firms that I point to, they have algorithms in there that will, you give them a word and they will come up with all kinds of vowel substitutions and consonant substitutions they will include in their search for you, and that's what you pay for. What you get back is essentially just a list of everything they found, and it takes an experienced eye to go through and decide if there's a conflict or not. Also, you should know that in the U.S. And in most other places in the industrialized countries, when you apply to register, the USPTO, for example, will take your mark and see if there's a conflict with marks that are already in their database. And there are some startups that, when you tell them this, they'll say, you know what, we can't spend the money on our own clearance search ahead of time. We're just going to throw this into the registration pool and see what the trademark office does with it. Now, again, the trademark office is limited to its own records. And it's relevant if there are other companies out there using maybe the same mark or something very similar, and maybe they're not even registered, but they would still be able to cause a problem for your branding, for your registration process, and even take you to court if they perceive an infringement. Still, the registration process does something for you, and some companies will say, we'll go ahead with that. And if we get that dreaded cease and desist letter at some point, we'll deal with it. You might end up having to change the mark, and rebrand. And, the farther down the road that happens, the more painful it is. So it's always better to be as knowledgeable as you can be upfront when you're choosing the mark. But the reality is that there are companies that just go forward with registration. So again, how do you get rights in a mark? You start using it, even if you haven't spent the money to register. Once you start using it and it's out there, you have rights to it. And the reason for that is twofold, and they're two sides of the same coin. One is that the law recognizes that once you've invested in your business and you've developed, you're starting to develop anyway, a following and a reputation, that's something you should be able to protect as yours. Also, customers rely on it. They go to stores or look for services that are going to make them happy, that will do, and service providers that will do well by them. And if the branding message and the customer experience that's attached to a particular symbol, a trademark, is something they rely on, the law says that the public should be able to rely on that. And in fact, there's an obligation on your company. If you have a mark that's out there and you know that someone else is writing on it, you're supposed to do something about it. And if you don't, it looks like an abandonment. And you're sort of saying, hey, it's open field. Anybody that wants to use this can. Okay. So when you're going to use it and you gain rights in it, use it properly. I'll give you some examples. And again, register the mark everywhere where it's important to you. Registration does a couple of things for you. I just mentioned, first of all, that the first place to look if you want to avoid a conflict is in the register. If you're not there, your competitors won't know. And the newcomers will come along and they may adopt the same mark. And then you've got a problem that you have to deal with. You don't want that. So one of the best advantages of registration is maybe one that's unseen, but basically, those other companies that come after you, if they're doing their job right, they'll see your mark there and they'll avoid it. And that's good news. The other thing is that if there is a problem that arises by a latecomer who uses the same mark or a competing mark, or maybe someone that does some bad advertising and throws dirt on your reputation, the fact that you're registered gives you legal advantages in court if you have to get there. But how do you use this? It's important to use the mark properly in your advertising, even if you don't register. Okay. Um, when you display the mark, first of all, put it in a size and a font that's different from the rest of the text. Okay, like I have here with the word visual. Use the symbols that tell the public and hope maybe a judge, hey, this is not just a word in our advertising text, and we're not just describing our product or service. This is proprietary. Okay, and when you register, use that circle R. It's actually illegal to use the circle R if the mark is not registered. And the other thing is getting back to avoiding genericide is grammar. So here's the rule. Okay, a trademark is an adjective to use with the noun. The noun is your product or service. Okay, the mark is not the noun. So the right way to use Acme as a trademark to sell servers is something like get me or go out and buy an Acme server for your network. Okay, this identifies what kind of server, actually, who's selling the server that you want. The wrong way to say it is to say get an Acme for your network, because that turns it into the thing itself. And who knows, people might start substituting that word for the word server, and the trademark has died. Oops. Okay, just checking in. Good. All right. Let's go back to the next slide. I see we're getting close to running out of time. So I'm doing pretty well. Just about done. Share the screen here with PowerPoint. Share. Okay. So just some examples of good usage in advertising copy. Notice this is the mark is the Intel core, and the generic part, the noun part, is the processors. Okay, and here's American Express putting their mark up and talking about getting corporate credit cards. Okay, they're not asking people to get an American Express. They're saying get a corporate credit card from American Express. And if you tune your eye into this sort of thing, you'll see some of the better advertisements out there, and you'll also be able to spot the ones that aren't really done properly. So the proper usage prevents, look at this, self-sabotage through improper usage. Again, use it as the adjective, not the noun. Improper licensing. You may come into a situation where you're partnering up with another company and you want to co-brand or something. You've got to keep control over what other companies do with your marks. Okay, it's a legal obligation. If you don't, and just even if you write up an agreement and says, yeah, you can use this for the next 2 years, and I'll use yours, and you don't say anything more, well, face palm. You've really done damage to your ability to protect that mark in the future. You want to stop the competitors who ride on your goodwill to enhance their business, and these are the ones that you're superior to in time. Okay, these are the latecomers who take up marks that are too similar to yours for comfort. And again, there might be comparative advertising or something like that. Comparative advertising is allowed, but it has to be truthful. So when you see ads that say something like, our laundry detergent works 10% better than brand X, they can name brand X, but they better have data to show that what they're saying is true, or at least that there's a good basis for saying it. Certainly, if it's not true, the victim of the business that's a victim of that kind of a message has a right to go after them, and they have an obligation to protect their marks and their brands. You have an obligation to your customers, and you have an obligation to your shareholders. Okay. So we talked about no naked licensing. So these are, again, situations where infringement happens and you're obligated to send a cease and desist. Okay. what are the things you do to protect your mark? Monitor third-party use, and one really easy way to do this is to set up Google alerts, for example, and just see what people are saying about your mark. Okay, and if there are obvious variations, the Red Bull people might have a Google alert for Green Bull or Black Bull or something else like that in the drinks area. So have those out there and pay attention. There are commercial outfits that will actually scour new filings in the trademark registers to tell you ahead of time. And the US PTO, the European, and others, they actually have procedures where if a prior registrant becomes aware of a new application that looks like it's going to be a problem with them, you can actually oppose the process in process and try and stop it from happening. When you see it in the marketplace, you send your cease and desists. Okay, register your marks. Again, it's a preventative measure, but it also gives you legal advantages. Should you have to go to court. Also, and this is really big, enroll in social media and supply chain brand protection programs. Okay, there are other places besides trademark registers in the government to register. Amazon has a brand protection program, and you can register if you're in Facebook. There's things you can go there to put your brand in as owner, and they have mechanisms for objecting to misuse by others. Other trademark offices have similar things. The U.S. government, if you are dealing in products that might be imported, you can not only register your mark with the U.S. Trademark Office, you can also register with the Customs Service. Okay, and they have the power to block imports that look like they're branded with something that infringes your mark, unless you're outsourcing and importing those things yourself. Just doing a time check. I've got about 5 minutes left to go. Yeah, so I've covered the basics here. And I'm going to check to see if there's any last question here. Okay, so that's basically the presentation for this hour. I'm happy to stay on and engage in a chat, answer any questions that remain. And if there are none, I certainly invite everybody to reach out with any questions if you want to follow up. Again, I want to give thanks to Techstars for organizing this. I thank you all for your attention, and look forward to maybe running into you as your business grows.